Hello and welcome. I'm Amritan Shira and you're watching Law of the Land on Sabha TV. Today we bring to you the Supreme Court judgment holding that government servants have no fundamental legal or moral right to go on strike. To discuss the issue, I have with me Professor S.C. Srivastava, Secretary General, National Labour Association, and Mr. R.V. Subbarao, Senior Activist, Bharatiya Mazdoor Sangh. Now for the headlines. The Supreme Court judgment ruled out any possibility of strike for government employees. The Industrial Disputes Act allows industrial workers to go on strike. And the law lays down conditions for workers in public utility service before they go on strike. There is no fundamental legal or moral right for government employees to go on strike. This is the law of the land as ruled by the Supreme Court. The court reiterated it in a case in which about 2 lakh government employees of Tamil Nadu had gone on strike.
The Supreme Court in its judgment has reasoned that there is no moral justification to go on strike. Government employees cannot claim that they can take the society at ransom by going on strike. Even if there is injustice to some extent, as presumed by such employees, they have to resort to the machinery provided under different provisions for redressal of their grievances.
Of course, right to strike must be as a last resort. It can't be done at the drop of a hat. But if there is a persistent denial of employees' genuine grievances, no inclination at all to look into the problems, the workmen are constrained to go on strike. And to say there is no moral or equitable right, I don't think that's at all justified. If not a fundamental right, certainly in a given case, workmen may have a moral and also an equitable right to strike, because that's the only weapon in their hands when they are faced with the insensitive.
The judgment was delivered by Justice M.B. Shah and Justice A.R. Lakshmanan in 2003. According to the judgment, government employees have no fundamental right to resort to strike. The employees don't have any legal and statutory right to go on strike. There is no law which empowers government employees to go on strike. The court referred to the service rules of government employees which specifically discourage strikes. The Apex Court also ruled out that any justification of a strike on moral grounds will not be accepted because government employees are responsible for delivery of essential services for the citizens.
Unfortunately, India, being the founder member of the ILO, has so far for all these years has not ratified this Convention 87 and 98, which governs collective bargaining. 87 is basically right to organize and form associations. 98 is collective bargaining and all.
Tamil Nadu has sacked over 2 lakh employees for going on strike. The reason given by the government was that the service rule of the state government prohibits government employees to go on strike, which was violated by the employees. Later on, the government reinstated most of the employees voluntarily after giving an undertaking to the Supreme Court. The state government had argued that the state employees 12 lakh persons and 90% of the state's income was spent on salaries of government servants.
The judgment faces criticism as it is against our International Labour Convention, where workers have given the right of collective bargaining. With camera person Shivi, Aruna Thakur, Rajya Sabha TV.
The Supreme Court held that the strike of the government employees was in violation of Rule 22 in Tamil Nadu Government Servants Conduct Rule 1973, which prohibits its employees from going on strike. My question to you, Mr. Srivastava, first of all is, it's the government servants who have been, on whom the judgment applies. But what is the implication of this judgment on non-government employees?
Well, I think this particular ruling is applicable only to the government servants or those, in this particular case, even teachers of the aided schools, government aided schools.
All essential services.
Yes, all the essential services, they were actually covered under this.
Does it have any implication for non-government employees, even in the sense that they feel that a large section of the employees have been deprived of certain rights?
No, see, we must make a distinction between the government servants and those who are covered, the industrial workers. So far as government servants are concerned, the law is, but before I do this thing, I must tell you that even in 1962, the Supreme Court in All India Bank employees case has very clearly laid down that there is no fundamental right to go on strike under the Article 19(1)(c) of the Constitution. So this is not a new law which is coming up. The Supreme Court has referred to and followed that
reiterated
it even in 2003. But looking to this problem, so far as industrial workers are concerned, the law is laid down under the Industrial Disputes.
We'll come to it in the next segment.
That's right.
I'll get in Mr. Rao on this aspect. What is the implication of this law on non-government employees in terms of morale, in terms of the existing liberties that the workers, non-government employees have been enjoying and still till date continue to enjoy? Is there some impact, some?
Definitely there is a impact in regarding the emotions and right of strike. They feel that a major section of the workers are deprived of this strike, and so they are worried, and it may also be extended to the industrial workers. So they are having apprehensions that it may affect their freedom of going on strike.
Okay. My question to you, Mr. Srivastav, now is, what happens in a situation where the government employees have a genuine grievance? Well, what is the option that they can now exercise? Because they can't go on strike. They can just seek for redressal under the scheme of things that have been provided for grievance redressal.
Yes.
But despite all these courses or recourses, if the employees' grievances are not being redressed and there is a persistent denial or a genuine denial, then in what situation, what can the government servant do?
Well, I think there is a clear law on this point. We have the Administrative Tribunals Act where they can approach, and this is precisely what the Supreme Court has pointed out, that they have an alternative remedy to approach the state administrative tribunal or the central administrative tribunal, as the case may be.
Are the tribunals in good shape?
Well, I think that's a real problem. Particularly it arose in the case of T.K. Rangarajan versus State of Tamil Nadu, where there was only one vice president. It was not constituted, and therefore the Supreme Court even directed in that case that the government must take appropriate measure to fill up the vacancy.
Mr. Subbarao, any improvement since 2003 on the improvement of tribunals and the way they address the grievances?
We don't find any improvement, and particularly in labor matters, the government is neglecting in the respect of filling up the vacancies, if not providing extra staff for the extra load. The same thing is affecting labor ministry, labor conciliation machinery, as well as labor courts.
Is there a will on the part of the government to actually, especially in the scheme of things of liberalized economy, do you think the labor rights are gradually decreasing on a daily basis?
Well,
through judgments, through non-interference of the government, through proactive approach of the industry and several other issues, and no will on part of the government to actually act on behalf of the labor. Is there a feeling of this kind?
No, well, I think there is a feeling, at least on the part of the employees, because they feel that in the name of globalization or privatization or liberalization, even the Supreme Court is liberal in this approach, and the Supreme Court is now emphasizing more on discipline in the industry itself. And the name of the discipline and the name of the globalization, even some of the decisions of Supreme Court, they have tried to maintain industrial harmony, and they want to say that we want to maintain discipline in the industry.
Mr. Rao?
That is what we are observing from the judgments. They have reversed the earlier judgments and they have put forth this. But there are 2-3 judgments also in the same situation, where the courts again reminded the government and the officers their responsibility and their constitutional obligation. They have clearly stated that it is not the economy, the LPG, the policies that are to be seen, but the constitutional provisions should not be forgotten and they must be implemented. Courts should attend to their own job of interpreting the.
Mr. Rao, what I want to understand is these are 2 judge benches or 3 judge benches, because there is already a 3 judge bench which takes away any kind of strike rights.
Yes.
Now, the judgments that you are talking of, are they 2 judge benches or 3 judge benches?
Just these 2 cases pertain to reinstatement of employees who are retrenched illegally, but not related to the strike issue.
Not strike.
Yes.
So which essentially means the strike, as it has been upheld by the judgment, those continue to be the law of the land.
Yes,
right?
Yeah.
And takes away a substantial portion of right from the government employees.
Yes.
Time for us to head into a break. When we come back, we will talk about the law which allows industrial workers to go on strike. Welcome back. The law allows industrial workers to go on strike in certain conditions. The Industrial Dispute Act of 1947 allows workers in the public utility sector to go on strike after fulfilling certain conditions.
The strike at Maruti Suzuki's Manesar plant may have taken an ugly turn, but industrial workers are legally allowed to go on strike. The Industrial Dispute Act does not prohibit the workmen from going on strike, but requires them to fulfill conditions before going on strike.
They, under the weight of neoliberalism, the obnoxious and ferocious attack, all-round attack on your service security, your service condition, your social security, your pay, wage and inequality, all those social ills and odds and onslaught in one side. And you say you shouldn't make any sound, you shouldn't oppose. What does it mean? So these are implications, I will tell you, and we don't agree, we oppose, and we shall continue to support the right of the government employees also as well to go on strike.
Let's look at the provisions of the Industrial Dispute Act and what it says. According to the law, strike means refusing to work by a body or persons employed in any industry. The law says whenever employees want to go on strike, they have to follow the procedure provided by the law, otherwise their strike will be illegal. It provides that a person employed in public utility service may lose his job if he goes on strike without giving notice of 6 weeks in advance to employer. If he goes on strike within 14 days of giving such notice, if he strikes before the expiry of the date of strike specified in notice, and if he goes on strike during pendency of conciliation proceedings, and if he strikes work 7 days after the conclusion of such proceedings.
Nevertheless, in spite of that judgment of the Supreme Court and all, these central as well as state government employees have been going on strike and all. But it would have been better if the government changes these service rules. Of course, in special circumstances and all, certain restrictions are to be put and all. That right cannot be, and I think should not be given to the armed forces and all, which generally are the embodiment of the state. But for central and state government employees who are bank employees and all, that right should be, they should be free to exercise this right.
The Supreme Court has highlighted that where there is a large-scale unemployment and numbers of qualified persons are eagerly waiting for employment in government departments and in public sector undertakings, strike cannot be justified on any ground. The court said that the government employees are part and parcel of governing body and owe duty to the society.
In a democratic country, if you prohibit someone to fight for injustice done to him, even on the moral ground, then the meaning of democracy will fade away. With camera person CV, Aruna Thakur, Rajya Sabha TV.
One set of citizens are not allowed to strike, but another set of citizens are allowed to strike. Mr. Rao, my question to you is, under what circumstances should the industrial worker be allowed to go on strike under certain conditions, but the government employees should not go on strike?
For this, there is no, the very discrimination is incorrect. Both are wage earners, both are expected to do something and they are doing. When their issues are not solved, they have to express their feelings and resentment, and we have to take some action to make the employer to do his job. Unfortunately, we are only thinking about strike and what it is affecting the nation and economy. But who is the cause for this strike? How the cause has arisen? Who is responsible for that? Without cause, strike would not have taken place.
Yeah.
So, that way, without thinking, the courts so far have never said anything about the actions of the employer, particularly in this particular case of government employees, who is a government. If the action of strike has arisen out of the failure on the part of the government, that is the employer, to do its job.
Is there a feeling that the government is probably not doing enough, or is it possible, I will put it the other way, is it possible for the government to please all its employees?
Well, I think before I answer this question, it would be necessary to make a line, because so far as the government is concerned, there is a government service conduct rules. But so far as the industrial employees is concerned, they are governed by separate law, and that is the Industrial Disputes Act 1947. Now, if you are looking to the problems of the government servant, see, the thing is, there is an alternative remedy available to them. This is what the Supreme Court has pointed out.
The administrative tribunal.
The administrative tribunal. And for their grievances, they can approach to the administrative tribunal.
Which is not available to industrial workers, you are saying.
Particularly in this case, you cannot make generalization on this basis of this, because each state has got its own
set of rules. My question to you is it possible for the employer to satisfy all employees?
This word satisfaction is confusing. The satisfaction is a very ambiguous word. If you cite a specific example, we can give reply.
Okay, the question is, I'll frame it otherwise. Is it possible to keep all the employers happy and content and fulfilled in the role that they are doing by the employer? Is it possible? Is it within the wherewithal of the employer to please everyone so that it negates the chances of any possibility of a strike? Is that a possible thing?
Definitely. Employer, there is every possibility employer can do, and see that displeasure or resentment is not aroused among the workers.
So that's possible. Yes. Second is, why do you think, Mr. Srivastav, Professor Srivastav, is the government not trying to ratify the ILO 1977, 97 and 98, collective bargaining and the other right? Why is the government reluctant on, because it is, allowing whole lot of other international treaties that it has signed and everything, but why not on this front? Do you see a lack of will?
Well, I think it's not only lack of, even in our constitution itself, if you look to Article 19(1)(a) or 19(1)(c), which gives a right to form associations or union, it is not an absolute right. There is a qualified right that it is subject to sovereignty and integrity and public order and morality. So this is one constitutional difficulty which is there. Then government servants, see, they are, as the Supreme Court has pointed out, they are governing body. They govern also, and if the government servants go on strike and they are allowed to resort to all these methods, then what will happen?
No, we are on the point of, I get it. Mr. Rao, we are on the point of why isn't the government ratifying the ILO?
Government, particularly in our country, is not following the same rule or policy or principle for all categories of employees. We have unfortunately inherited the law, the rules of service and conditions laid down by a British alien government, and divide and rule has been their policy. So we find today each issue is not common between all categories of employees, government employees, private employees, among the government, bank employees. Now, I can cite bank employees, State Bank of India employees are having a right to contest elections while in service. If they lose, they will continue back to their service. But this is not available to all other government employees, or in certain banks this is not allowed.
Time for us to enter into a break. When we return, we will show you an interview with Brijnath Rai, General Secretary, Bharat Mazdoor Sangh. Welcome back. My colleague Aruna Thakur spoke to General Secretary Bharatiya Mazdoor Sangh, Brijnath Rai, and tried to get his point of view.
The judgment specifically restricts the government employees that they don't have the right to go into strike, not even on the moral or equitable ground. So, as a trade union leader, what will be your opinion on the judgment?
As a trade union leader, we must say that everyone has got the right to strike as a freedom belonging to them as a citizen rights. The only exception which we can make, the persons or the employee who are involved in the process of the sovereignty of the government, of the India, of the country, they should not be allowed for the strike or any trade union function because of the issue where sovereignty arises or sovereignty will be affected.
We have also international conventions related to labor laws. Does it specifically restricts the government employees not to go into strike?
100%. International conventions, those who are core conventions, they have, by that convention our government is compelled to ratify it, and while ratifying he has to accept collective bargaining for each and every employee, whoever so be. What I earlier said, that in collective bargaining can be done with anybody. Even IS officers are doing collective bargaining today. So, collective bargaining has no limitation. The issue of a strike has some limitation.
As a trade union leader, what will be your suggestion regarding our labor laws in India?
Yes, we want to impress upon the government of India that they should immediately ratify all the core convention of the ILO, which the process is going on. Already a meeting was held on the 25th of this month, last month. So the process is going, but expedition is very much necessary.
The Supreme Court has in various judgments held strike by government servants illegal, but it was most impactfully articulated in T. Rangarajan versus Tamil Nadu case. Now, my question to you, Mr. Professor Srivastav, is uniform law possible for all
Well, I think
workers?
It is not at all possible. The reason is even the law itself has made a distinction between the workers who are in the public sector, workers who are in the non-public sector, even in the industrial, workers. If so far as the government servants are concerned, there is separate legislation to deal with this. There is all kinds of legislation. We have the government service conduct rules, but there is a separate rule for the same, and therefore they have got a special protection under Article 311.
I get it. Mr. Rao, is it possible for the government to bring one overarching uniform law for all, which will be the guiding principle for?
That is possible. At least for certain, in the government jobs, all seats, all tables are not of the same importance as our learned professor has expressed. That is sovereign functions, related to sovereign functions, we may say. But there are at least 80 to 90% of the posts in the government are not related to the sovereign functions and decisions, policies related to sovereign functions. Then such employees, why they should be discriminated?
I get it. Obligation. The suggestion made by Mr. Rao was that if the employer fulfills its obligations, then there will be no room for strikes.
Yes.
Is that possible?
Well, it is not, because how will you judge that what will be, it all depends upon the demand itself. What is the satisfaction and what is not satisfaction, it has to be judged not only from the point of view of the workers, but it are the employees, but it has to be looked in the overall context, because consumers are also going to be affected.
I get it. 1, 2, 3. Can you tell me what the obligations, principal basic obligations that the employer must fulfill?
That is, terms of service related to working hours and overpayment of overtime and weekly off and other rest. Then wage rate and payment of DA when the according to the price rise and social security measures. These are the basics for which the worker is expecting some relief from the employer and adequate remuneration and facilities. These can be equal among workers.
I get it. I get it. On the remedy for the unorganized sector and the industrial workers, what is the remedy?
Well, I think so far unorganized sector is concerned, let me say and repeat it rather, that we have 93% of the working population, they are in the unorganized sector. And most of the labor laws in the statute, they are available to them, but in practice most of the labor laws are not applicable to them. As this law has referred to the Equal Remuneration Act. To begin with, I think we must provide some minimum standards for them. Take a case of maintenance, some social security benefit should be provided to them, because that is what a step has been taken. We have the Unorganized Workers Social Security Act, where we have tried to provide, but this act is merely provides a skeleton for the same. So,
Mr. Rao, do you think it's possible? The unorganized and the way unorganized numbers are there in unorganized sector and the remedy available to them, given the lack of education, literacy and all those issues in that sector?
Now, here I differ on the very definition of unorganized sector and organized sector division. Wherever, whichever may be the sector, where the work is, a worker is getting wages, wage worker is existing, they are all equals. Unorganized in the sense, it depends on the, not the terms of employment, it is depending on the employer in whichever category he is functioning. That is, registration and licenses are issued to the employers. Such of the organizations which are licensed and registered and functioning under some law
are organized
sector. And in the organized sector, all the workers, they should be treated as organized workers, and there cannot be unorganized worker in an organized sector.
I get it. So that is where the violation is happening.
That is the violation.
Under the banner of organized sector, you are keeping workers in unorganized fashion. I get it.
Yes.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.